Hey everybody, how's it going? Welcome back to Copper Jacket TV. So today we're going to be talking about a federal judge that not only insulted the Supreme Court in saying that the Supreme Court's Bruen decision was unintelligent, but also denies an injunction against a clearly unconstitutional carry law. Let's get into it. This channel is proud to be sponsored by the US CCIA. Listen, if you carry for your own defense and you don't have a lawyer, you don't have an attorney, or maybe you just don't have the money in the bank to defend yourself, you need a US CCIA membership. With your membership, you get that self-defense liability insurance. You get a lot of other resources that you're going to find online, a lot of training and tips that are going to help you while you're out there, and SDI. If you guys have ever wanted to get into, let's say, gunsmithing or armory classes, you want to know a little bit more about that, check out the link down below to SDI. It's a phenomenal place to learn and really take your hobby to the next level. So let's go and start off by taking a look at what this federal judge said about the Bruen decision, which insults the Supreme Court. Now, this is directly from the FPC's Twitter account, and I'll read you guys this quote. So from the FPC's Twitter, a federal judge said about the Bruen test is considered by many to be an impractical and intellectually flawed approach. So this federal judge out of the state of New York, obviously, thinks he knows better than the Supreme Court. He thinks he knows better than Justice Clarence Thomas and the other justices who were in the majority supporting the NYSRPA and the Second Amendment in this case. He believes that their opinion was intellectually flawed. Again, that's a pretty bold statement to make from any federal judge, but I would expect it from any federal judge from the state of New York to California. That's just kind of how they look at things. If it doesn't work out in their favor, their own personal beliefs, then it must be intellectually flawed. Okay, so with that being said, let's go ahead and talk about the injunction that was just denied by that very same judge. Now, this is a very important case. I don't know if you guys have noticed, but across the country, since the Bruen decision, blue states have been cracking down on sensitive places. They've been adding sensitive places. They've been doing it quite a bit, and I don't think anywhere is a bigger offender than New York with their CCIA, the Concealed Carry Improvement Act. One of the places that they added as a sensitive place is house of worships. House of worships are being considered sensitive places now across the country. Well, in New York, a set of Jewish congregates decided to take New York to court, saying that it violated their First Amendment, their Second Amendment, their 14th Amendment rights, and that there was less people showing up because they didn't feel safe in their place of worship anymore. And so obviously that was causing a problem. Now, New York did update the CCIA to say that they could have some type of armed security, but it had to be licensed security. People couldn't go there on their own. Again, people were feeling less safe, so this lawsuit was brought forward. Now, this lawsuit had like 6 different defendants. It was Kathy Hochul, the Attorney General, and other people that were involved with implementing or enforcing the CCIA. Now, this is, to me, clearly a violation of the Second Amendment. It clearly goes against Bruen, but as you can see from that statement, I don't think the judge really cares that much about Bruen. But regardless, I read the 44-page order that the judge handed down in this, and it just came out today, and it was kind of a long read. But the judge cites things from 1870 and, all over the time period from before we were a country till, a little bit after the Reconstruction era, saying that states had banned things in certain areas and that states were allowed to create sensitive places, and that churches and synagogues and places like that could be considered sensitive places. And he just basically blew it off. I mean, he went through all the standard procedures. All of the procedures are listed in there as to what he needs to consider, and all of the, text and analysis of Supreme Court precedent was in there. But he pretty much brushed all that off in the end, and it really seemed like he balanced public interest in favor of the state. That's what it seemed like in the end. So while in the beginning, while I was reading it, it looked like what he was doing was kind of, balancing the way that things should be in Bruen by showing some type of historical analog and at least looking back in time. But in the end, his decision basically says that in balancing the interest of public safety, he has to consider that, and so therefore he's going to deny the injunction, and that houses of worship are going to remain sensitive places. Now, the reason that I've said in the past that this judge basically upholds the CCIA when really all he's doing is granting or denying to grant an injunction in it, is because he believes that in this case the plaintiffs don't have a good chance of winning on the merits. He's looked at everything, apparently, or at least he says he's looked at everything, and he says that the plaintiffs just haven't shown that much of a burden or that much injury that requires this type of immediate relief. And so in doing so, he basically upholds that CCIA, which is going to help out other states who want to do the same thing to houses of worship. So when you go to pray or you go to talk with whatever God you believe in, that's going to be a place where you're going to be less safe. Not going to be able to defend yourself. And that seems to be what's happening across the country right now. And this one was definitely a big loss. Now, real quick, I have a couple different problems here. Number one, I don't believe that places like Everytown and Mom's Demand should be allowed to jump on the side of the state, right? So if you have a lawsuit against the state, it's going to be whoever is supporting your lawsuit against the state, but I think the state should have to defend itself. In this case, Everytown was allowed to get on there and they were allowed to write briefs and get involved in the entire thing. And so basically what we have here is an activist arm that is reaching in to help the state restrict your rights. I don't think that should be allowed. I think the state should have to represent itself and no other party should be allowed to deal with that. But in the end, it doesn't really matter if you have some type of activist judge. If you have a judge who intends to uphold his own personal beliefs or her own personal beliefs, then it doesn't matter whose side is on who. The decision was already made. They just need to search for any type of relevant argument that would uphold their already previously held beliefs. And that's kind of what we've been seeing out of a lot of these district court or superior court judges from all the decisions across the country that are clearly unconstitutional. It's all these lower court judges that are in places that you already know what they're going to say before they even say it. You know, once it gets up to the Supreme Court says, no, you can't do that. And they continue to do it anyway. They just, find different ways. But this is a terrible one. Whether you're religious or not, that doesn't matter, right? You should have to understand that the state shouldn't have the right to just blanket sensitive place, a majority of the state. They're not allowed to do that. I mean, it said in Bruen that you just can't simply make sensitive place a sensitive place because a lot of people gather there. That's what Justice Thomas said. Well, that seems to be what they've done here. And this judge upheld it. So maybe he just doesn't understand. Regardless, I want to thank you all very much for watching. I really do appreciate it. If you haven't done so already, please hit that subscribe button, that little bell notification to let you know when new videos come out. And you guys have a great day.